Okay, good afternoon, everybody. Thank you for joining this webinar about Brexit. If if you listen to the news, I don't think a day goes past for probably the last 2 or 3 years where we've not had to listen to something about Brexit. So thank you very much for tuning in for this webinar. I'm recording the session, so I'll send out a link with a copy of the slides at some point after the webinar. So you can recap if you need to. If you've got any questions, we should hopefully have plenty of time for questions at the end. And there's a questions box in your control panel. So if you use that to ask any questions, and I'll pick those up at the end. Okay, so my name is Mark Gracie. I run the Digital Compliance Hub and a consultancy called Flavorfied Digital, focused on helping businesses with data compliance, so primarily GDPR, but also e-privacy and marketing compliance as well. My background is very much in a regulatory space, having worked in the internet and telecoms industry for the last, well, from sort of mid-90s to about 5 years ago. And one of the focuses of that was being a data protection officer and dealing with data retention and policies and procedures around that. We have been for some time being part of the EU, and so we have been very much driven in the UK by European data protection law. When I became a data protection manager back in '98, that's when the new Data Protection Act came in, which implemented the European Data Protection Regulation. And of course, last year, believe it or not, this May will be an anniversary of the first year of GDPR. So the General Data Protection Regulation was implemented, and that's a European regulation. Just to set out some clarity around that, the difference between a European directive and a European regulation is a directive is basically a set of rules that have to be implemented into member state law, where a regulation like the GDPR is a regulation that applies across the whole of Europe. And of course, whilst we are still part of Europe up until potentially the end of next month, GDPR applies to us as a member state of the European Union. Post Brexit, be that whatever might happen on the 29th of March, whether we're leaving with a deal or without a deal, whether it's extended, whether there's a people vote or whatever, it's worth recapping and understanding what Brexit could look like. And that's the purpose of this webinar. And I'm going to just do a bit of an introduction about where data flow from an international, so a non-EU perspective works. So just a quick recap of what the GDPR and what the law says about non-EU data processing of EU data, and then we'll look at some of the challenges that we will face if you process data outside the UK when we've Brexited, whether it's a deal or a no deal, and some other things for you to look at, and then I'll touch on what you might want to think about in terms of preparing yourself for a no deal Brexit. Which seems to be the trend at the moment, is everybody's preparing themselves for a no-deal Brexit. So let's get started and let's talk about some of the basics of data protection in terms of what international transfer means. So when we talk about the GDPR and data protection across the whole of Europe, basically any data relating to a European citizen should be protected and therefore governed by the GDPR. And that means that if you're outside of Europe and you're processing European citizens' data, so you may be targeting European citizens for products and services, GDPR applies. So it has that extraterritorial reach. But it also means that if you are going to be processing or transferring data outside of the EU, maybe you're passing your data to somewhere in the States or to another non-EU country, then that's referred to as a restricted transfer, which basically means that you can't process data outside the EU, with the exception of some conditions that have to be put in place. And those conditions basically say that if you process data within the EEA, so the European Economic Area, which is pretty much the EU countries plus a couple more, then that's allowed. So, you know, if you wanted at the moment today, if you pass your data to somebody in Germany to process for you, that's allowed. You don't have to do any checks and balances. If it's to a non-EEA country, then the rules are basically set out that you have to make sure that there is some equivalent laws in place. So, so if it's outside the EEA, you have to basically make sure that there's some checks and balances in place. And some of those checks and balances will vary depending on the country, depending on what agreements are in place. So there's three options essentially. Either the country has equivalent laws and an equivalency has been agreed with the EU, and most recently Japan and the EU have agreed that they have equivalent data protection laws, which allows for the flow of data to and from Japan in and out of EU. And there are another set of other countries, so countries like New Zealand, Israel, for example, are countries which the EU have deemed to be having equivalent data protection laws. So if you are transferring your data to those countries, then you're covered because they have equivalent laws. And there's a European website. In fact, if you go to the ICO's website, ico.org.uk, look at the GDPR guide, go to the international transfers section, which is, I think, right towards the bottom on the left-hand menu. You'll see that there's on that page, it will actually tell you slightly confusingly the different options, but essentially the different options, and also there's this section about equivalency. So it will tell you which countries are on that list and where you can find the EU website that gives out the up-to-date list of EU approved countries. So if you're processing your data in a country where there is agreed by the EU equivalent data protection laws in place, then you're allowed to transfer data to those countries for processing without any particular issues. However, to nobody's surprise, lots of countries outside the EU aren't on this equivalency list. You know, prime suspects, usually we talk about India with regards to call centers, and we talk about the US in terms of maybe using US-based cloud-based services, and therefore data is being stored on US servers, that kind of scenario. So we talk about India and US as a couple of sort of typical examples. Now, the US has an agreement with the EU called the Privacy Shield, and that basically allows for data to be transferred to US companies for processing, provided the company has signed up to the Privacy Shield. And the Privacy Shield is basically a self-certification that you abide by European data protection laws. So if a company in the US has signed up to the Privacy Shield agreement, then you can have them process your data on the basis that they will apply European data principles. There's some challenges, and there were some challenges last year from the EU towards Trump's administration around the fact that actually maybe Trump's administration aren't enforcing it to the extent that the EU were hoping, and particularly when there was these scandals around Facebook and what it was doing with sharing of customer data, there were some criticisms that the US government wasn't doing enough to enforce their end of the bargain, essentially, and at some point it looked like the Privacy Shield might be vetoed by EU, and therefore we would have then had to look at what that means. But at the moment, Privacy Shield exists, and the EU could consider introducing other agreements in place. So there's a Swiss agreement, for example, and different countries have different agreements for data flow as well. So there's a US Swiss agreement, for example. If we then look at the other example of India, for example, well, they're not in the EU, and their data protection laws aren't equivalent. There isn't an EU-India agreement on any kind of equivalent of a Privacy Shield. So then you've got to look at, well, if it's the India or any other country that doesn't fit into those three key areas, what are the options available? And to be honest, it's contractual. It means you have to make use of what's called the model contract clauses. These are set out in European law, and it's a cut and paste job. You find the regulation, you copy the rules or the clauses from the annex in the regulation, and you add those to your contracts. And that's basically binding in contract law that the company outside the EU is going to be processing your data according to EU principles and EU data protection. There's also a concept of binding corporate rules, which are used for internal transfers. So if you have a parent company in, say, South Korea, where there isn't an agreement in place and it doesn't have equivalent data protection, then you will need to make sure that that parent company doesn't have access to your data unless there is some kind of agreement in place. One thing is to use the model clauses, but you could use binding corporate rules, which is an internal contract between the parent company and the office within the EU. These have to be basically approved by, so in the UK, the ICO or the regulator. So these have to be approved, and that approval process is quite time consuming. So I think most organizations tend to go down the model clauses if they're given a chance. And again, even if you are dealing with a US company, you can still use the model clauses if you want. And I know of some organizations who don't particularly trust or want to trust the privacy shield scenario, and so they insist on the model clauses being in place. So essentially that's, as I say, a contract between both parties to apply European standards of data protection. Okay, so at the moment, today, we are within Europe, and therefore these rules apply. If you're transferring data to a European country, you don't need to worry because it's EU to EU transfer, and that's allowed. If you're transferring your data to a non-EU country, but there's an equivalent law in place as approved by the EU, then you don't need to worry because equivalent data protection laws will be applied. If you're transferring your data to the US, then you can make use of the privacy shield, provided the organization in the US is signed up to the privacy shield principles. Alternatively, you need to look at basically having a contract in place. In a post-Brexit world, of course, this then begs some questions. We are unlikely to be seen within the EEA. I mean, there is a possibility, and there has been noises made in the past, that we might be seen as part of the EEA, but not a member of the European Union. It could be that we are given equivalency status, so we appear on that list, and there may be some challenges about that. I'll come on to that in a bit. We could end up with an EU-UK equivalent of the privacy shield. We may all have to, and this is kind of the fail-safe, I guess, have in place these model clauses. So if you're transferring data, if you've got somebody from the EU transferring data into the UK and you're processing it, then there's a good chance that model clauses might be something to make use of, or there could be some other option. It's not entirely clear where the governments are. I think, as I said at the beginning, there's lots of news about what's happening with Brexit on a daily basis, and there's a lot of confusion about what it actually means in day-to-day scenarios. So it's not unimaginable that some other solution may be provided, but I very much suspect it's probably not something else. It's probably one of those other four, potentially the equivalency rule, but who knows. So if we now go on to Brexit and look at what that might look like, well, there's two scenarios. Again, if you've not been paying attention to the news, then you might not realize this, but there's quite a lot of suggestion we could be going down the no deal route, but essentially two scenarios. We have a deal, so the withdrawal agreement is approved, and that applies, or we have no deal where the withdrawal agreement isn't approved and we basically do a hard Brexit. So no deal is in place. There's no contingency, no transition period or anything. So I'm going to look at both of those scenarios. As you can probably imagine, the one where there's no deal is the trickiest, and the one that you might want to pay most attention to, because it's slightly easier if we go down the deal route. So in the deal scenario, that essentially means the withdrawal agreement that is still being debated is approved. That means we have a transitional period. So there's a transitional period of us leaving the EU, which concludes by the end of 2020, which means that all of the mess that I'm just about to talk about in the no deal scenario gets figured out and hopefully sorted, and that will include having some longer term solution for data protection compliance. And data protection is mentioned in these kind of discussions as well. So it's not just about backstops and agreements between Northern Ireland and Ireland, or trade agreements and things like that. Data protection is clearly a key part, along with a whole raft of other EU laws about how they might apply. So if we get the withdrawal agreement approved and we have that happens on the 29th of March, then it should be business as usual until the end of next year. And in that period of time, we're going to find out what is actually that longer term solution. And that might be, as I say, an adequacy agreement, or it might be something else. Excuse me. So in the trickier no deal scenario, basically there will be no transition period. So we won't have until the end of 2020 to work out what the situation is. And the likelihood is that because the government have said they're quite happy that if you're UK based and you want to pass UK citizens' data to the EU, then there's no issue. So data flow from UK to EU will be as normal. But in reverse, it's going to be restricted because we will be a non-EU country. And so therefore, if you've got a German organisation sending you EU citizens' data into the UK, all of a sudden we're considered what's called a third country. And there is no adequacy decision being made. There's no equivalent laws even though we have an equivalent law, it won't be seen as that because we have just completely dropped out of EU, and that equivalency test is quite a long drawn out period. I think the Japanese equivalency has been on the cards for the last year, if not longer. So in a no deal scenario, because there'll be no transition period, we will essentially be a restricted, or the data flow from EU countries into the UK will be a restricted data flow. So you will have to look at what that might mean. Let's move on to the next slide, because that's essentially the kind of things to consider. So in a no deal scenario, there's lots of different things for you to think about. If you operate purely in the UK and you're processing UK data and you only operate in the UK, then there's going to be no change. Nothing is going to make any difference because the chances are we will have a GDPR legal setup in the UK anyway. So as business as usual, essentially. Equally, as I said already, the UK government has indicated that if you want to pass UK citizens' data into the EU, then they're happy that that goes ahead as normal. So there should be no change. So if you're data processing on the continent, then you don't need to worry about anything in particular. Where it becomes a challenge is where the EU data is coming into the UK, with the UK no longer being part of Europe. So if you're processing EU citizens' data, then you're going to have to ensure that there are appropriate safeguards in place. And in a no deal scenario, there will be no transition period. There'll be no, therefore, GDPR, the transfer rules, international transfer will be seen, as I said, as a third country, and therefore we won't be seen to have adequate data protection, even though we do, because by law we won't be part of that list until it's all sorted out. So you're probably going to be looking at making sure that you have the contractual side of things in place. So everything that I said needs to be in place in the on this slide when we were talking about what it might look like from an Indian point of view. So you know, for all intents and purposes, we would be like India. So there's no equivalent law approved. There's no different agreement in place. There's no sort of equivalent of privacy shield. Therefore, we're outside the EEA, and we have to make sure of these model clauses. Now, if you sell products and services to EU citizens, you'll remember when I was talking about GDPR law in this area, it basically says that if you are targeting EU citizens for products and services, you're processing their data, You therefore have to apply GDPR. Well, in essence, that doesn't really make any difference. That's no change because you'll be used to a regime that is pretty much the GDPR anyway. Even when we've no deal exited, GDPR will still be part of UK law. But there are some very significant changes. So there's this concept of a one-stop shop, which from a regulation point of view. So currently under GDPR, and as the UK is part of the EU, we can benefit from the one-stop shop. So if you operate in the UK, you're answerable to your regulator, which is the ICO. And it doesn't matter whether you're dealing with German customers, Spanish customers, Portuguese, or whatever, you can say you are answerable to the UK's ICO. However, when we're outside, or if we end up being outside because of a no-deal scenario, you will be answerable to the regulators in each of the countries in Europe. So if you are processing German, French, and Spanish citizens' data, you will be answerable independently to the French regulator for French citizens, the German regulator for German citizens, and so on. So we wouldn't be able to benefit from this one-stop shop that exists across Europe, i.e. you just have to worry about what your regulator says. If you've got offices in the UK and within the EU, you will find that because of the same kind of scenario, you will be answerable to the ICO in the UK because you operate in the UK, but your EU offices or any other, so your EU offices will be answerable to the EU regulator in the country in which those offices are. So if you have an office in Spain that's selling products and services to Spanish people, then you'll be answerable to the UK ICO for because you're based in the UK, and you'll also be answered to the Spanish regulator because your office is in Spain as well. Now, there are certain types of processing activities that if you carry out outside the EU, so for example, the monitoring of behavior and general monitoring of data subjects, then the law also says you have to appoint your EU representative. So for example, if currently if a US company is processing data based on UK citizens, they need to have a representative within Europe to act as their European representation to basically deal with any of the compliance issues that might arise from your processing of that data. So in a no-deal scenario where we're no longer part of Europe and there is no agreement in place around data protection and therefore the data flows, if depending on the activity, there's a chance you may also have to have somebody employed within Europe who is acting on your behalf and answerable to the European regulators as well. And then finally, there is that question, surely the simple answer is we're going to get an adequacy decision, aren't we? Well, yes, there's a possibility of that. But as the ICO points out in its guidance on Brexit, these adequacy decisions take some time. And I alluded earlier to the recent Japan decision has been going for I think I said a year, but I think it's probably even been longer than that. So yes, it would seem obvious that we should get an adequacy decision because we are operating under EU GDPR law right now. But actually, because of the red tape and the protocols around all these kind of things, we would have to go through that whole regime of basically convincing Europe that we have adequate data protection in place. And one of the things that we're likely to see is just because we leave Europe, even with a no-deal scenario, doesn't mean all of a sudden there's no data protection law in place. The government have indicated that they will, of course, implement GDPR in a post-Brexit world regardless. But that doesn't make it any easier in getting an adequacy decision. So yes, adequacy decision seems to be the sensible approach. Some people have speculated that we may not get the adequacy decision because of some of the choices we make in other areas of law relating to data. So there's a big thing around data retention for certain operators. So as I said, my background's in telecoms law and regulation. And one of the areas there is that there was a European directive to basically set out rules around retaining of telecommunications data. So when so that's call records, logs showing when you're connected to the internet and which sites you might see and all those kind of things. All that data is governed by data protection because it's personal data, but there's a data retention directive that's that said that under some circumstances, particularly for national security purposes, then the telecoms operators can be required to store data for much longer than is necessary. Now, the way the UK implemented this, because it was a directive, not a regulation, so it's not boilerplate across the whole of Europe, it's on a member state by member state implementation. There's been a lot of criticisms from EU that the UK have gone far and beyond the intentions of the directive. Now, when we look at adequacy decisions from a GDPR versus GDPR perspective, then yes, of course, we are going to meet those adequacy expectations, and that should all be all well and good. But if we then look at some of this data retention policy and then the UK's approach to national security with regards to who's supposed to be retaining what data and for how long, all that kind of thing, if there is a general feeling in Europe that we've gone far and beyond the intentions of the directive, then that might be a fly in the ointment with regards to the adequacy decision. Yes, you've got the GDPR bit right, but no, you've got the data retention part right, and therefore we can't sign off the adequacy decision. This, of course, is all speculation, so it's difficult to know whether this is going to be the case and what might be the outcome. But it just highlights the complexity or more importantly, that it may seem simple that we should have an adequacy decision, but it might not be. And then, as I say, in that last bullet point, as I said already, of course, there is some questions around how quickly we might get this adequacy decision and when it might be. So in a really bad no deal scenario from a data protection point of view, we'll be cut off from Europe from a data protection compliance perspective, and you will then need to consider what does that mean to your organisation if you are processing European citizens' data in the UK, because the UK will be, for all intents and purposes, considered a third country, so very much like India is right now. So that is, it's not that there aren't the solutions in place, it's just that the solutions aren't going to be easy, and you're going to have to make sure that you have contracts in place. So some further things to also just think about, and I'll talk a bit more about what preparing for a no-deal Brexit might look like in a moment. But just a couple of other notes, and I've kind of spoken to some of these already. We're likely to get a new data protection law. Yes, we've got a Data Protection Act 2018, which kind of implements the GDPR, but it will be more of a transition regulation that says GDPR in Europe still applies in the UK. So you need to look out and see what that might look like and see whether there's any complications or anything that needs clarifying from that perspective. The other thing is, if the EU decides to produce the GDPR plus regulation or some other changes to data protection laws, then how's that going to impact what we have in the UK? And I think this is probably going to be a challenge with the adequacy, because the UK will need to keep up with what the European countries or the regulations say with regards to data protection. So it's important to pay attention to what might happen to UK law based on any future changes in data protection updates. And of course, there's a good chance the ICO, in terms of enforcement, is going to be driven by a lot of paying attention to what's going on the continent anyway in that regard. But don't think that a no-deal Brexit or even a Brexit with a deal is going to mean that we will be able to ignore what's going on in Europe in a data protection point of view, because if we want to exchange data with our closest countries on the continent, then there's a good chance that some of the European decisions are going to impact on what the UK does, both in terms of national law and any other kind of adequacy or enforcement of those laws. And then finally, for anybody who's been following the changes coming with e-privacy, or when I say they're coming, they may not be coming, or if they are coming, it might be next year and it could be this year, who knows. So the e-privacy regulation is an update to the privacy directive, the privacy regulations that are implemented in the UK as the Privacy and Electronic Communication Regulations of 2003. And those govern, amongst other things, the law around the use of cookies on websites and also the laws around electronic marketing. So these are the things that say you must have consent if you want to send marketing emails to consumers that you don't need for B2B messaging and so on. Now, there has been for the last few years a discussion about a new updated e-privacy regulation that might change all of this. And it was originally going to be enforced from the 25th of May 2018, i.e. the same time that GDPR came into play, but it's just not happened. And then due to some complications in the way that the EU is governed, and the change in presidency, and the fact that there's going to be some EU elections happening this year sometime as well, the current speculation is we'll be lucky if we see anything on this until next year, which from a transitional period, if we get a deal in terms of Brexit, then there's an issue as to how that might be implemented in the UK. But in a no-deal scenario, there's equally the similar kind of questions. What will happen with an e-privacy regulation which has been implemented in UK law in the past that is updated, and how's that going to be implemented in a post-Brexit world? Because even if it gets published in the official journals next year, say in 2020, then there may be a year or 2 year transition period where we'll be clearly outside the Brexit transition period if we get the withdrawal agreement agreed, or if we don't and it's a no-deal Brexit, then we'll be completely outside of Europe anyway, so we won't be governed by European law. But that doesn't mean that the UK won't look at what the e-privacy regulation means and potentially implement it. So you need to pay attention to if and when the e-privacy regulation happens, B, how is that going to be implemented in the UK law? And just very briefly to put that into perspective, as well as changes in the way that cookie laws are likely to work, there is some suggestion in the current drafting of the regulation that B2B marketing will require consent, just like it does for B2C, business to consumer, which is essentially the German model, but not the current UK model. So there is a good chance that we might see some changes. And again, it's about paying attention to what the UK government might do in terms of implementing those regulations in a post-Brexit UK. Okay, so if we are to think about what Brexit actually means in a practical sense, then we're all being told that if you operate in Europe and you have products or services or parts, or they're hearing about all this stockpiling of medicine and food because we're not going to get it in from the Europe in a no-deal scenario, all those kind of things. But we're being told to prepare for no deal, and I'm afraid to say that data protection is no different. If you are dealing with European citizens' data, i.e. non-UK European citizens' data, then you're going to have to think about the worst case scenario of what a no-deal Brexit might mean. So in terms of things that you can think about, well, firstly, it might look differently, but basically data protection is still going to apply. So don't think you can just sort of relax and not worry about GDPR anymore. The UK is going to have a GDPR-like piece of legislation, and therefore you're going to have to apply UK data protection law, albeit GDPR, but in a slightly different guise, perhaps. You need to look at your data flows and see, can you identify where data is being processed outside the EU, or where you're processing European citizens' data, and how that's going to be impacted by what a no-deal scenario might look like based on what we were saying earlier. You're going to have to review your policies and procedures. So as well as understanding your data and your processes and how you're processing that data, which is best practice anyway, because you ought to have all of that documented to meet the requirements of GDPR. You also need to understand what policies you have, and also whether they will need to change, particularly if, and there's a lot of agreements out there, data processing agreements, or even policies that make specific reference to the EU GDPR regulations. Well, in a no-deal Brexit scenario, the EU GDPR rules will not be applicable. So you'll need to update your policies to perhaps reflect that whatever the UK law relates to data protection is applicable, rather than being very specific about European regulation. And you'll need to, in your analysis of where you're processing your data and how you're processing it, you ought to review any data processing impact assessments, or DPIAs, that you've got in place, because you need to make sure that you've got the right protections and the right processes in place for a no-deal Brexit. And one of the key things which you should be doing anyway on a as regular basis as possible, but we're looking at a 2019 being a year on from GDPR, and that's a prime time to do a review anyway. So you should be thinking about refreshing your employees to make sure, training to make sure that they understand how data protection impacts them. And you probably need to include some kind of Brexit related training or information to provide it to the relevant teams, because they may have to change the way that they're processing data. So it all sounds very simple. I'm sure it's going to be much more complicated than that. There's lots of uncertainty in terms of what a no-deal Brexit might look like from a data flow perspective. Are we going to have a new UK law? Is that going to be seen as adequate? How long is that going to take if it is? Are there any challenges that might mean that we need to have a privacy shield type scenario, or are we all going to go down the route of having model clauses? Because, to be honest, model clauses is the answer for most scenarios. You can't rely on the adequacy happening in a no-deal scenario very quickly, and therefore using these model clauses in those contracts between your the European countries that you might be processing data for is probably going to be the safest bet. So in fact, that probably ought to be a bullet point on this preparing your business slide. If you're looking for some help, just a very quick sales pitch for the Digital Compliance Hub. Digital Compliance Hub is a support service I run, which is a cost-effective way of basically getting the equivalent of a data protection officer support. So whenever you have a question or some challenges around what you're doing with data protection, with privacy and electronic marketing compliance, then there's a helpline that you can call and make use of, or via phone or email, and that's all backed up by a resource of guides, walkthroughs, toolkits, checklists, and we regularly run workshops and webinars like this one to bring everybody up to date. And of course, actually, it's quite a good way of keeping up to date with any new changes and stuff. So from a Brexit perspective, if you need some assistance in interpreting what it means to your organization in a bit more detail, then at some point, I haven't got stuff there, because there is so much uncertainty at the moment. It could change at any particular time. We'll have some information around Brexit, but you can make use of the support helpline if you've got any particular questions. So that's a Digital Compliance Hub, and of course, as a consultant, I can also sell consultancy-based services around that as well. So that was everything I wanted to cover, which kind of leaves us with 20 minutes of questions, if anybody has any questions. If you've got any, then please use the questions panel, and there's a few questions there already. So let me just have a quick look at those. Yeah, that's a good question from Alison. If you're a UK processor for a UK controller that transfers data to a sub-processor, what happens is there are no model clauses for the processor-processor relationship. Yes, that's absolutely right. So if you are processing UK data on behalf of a controller, so you are a UK data processor, and you send data to the EU, that flow of data, so UK to EU, is fine, because the UK government has basically said, we trust that the UK's data protection laws are equivalent to what is going to be happening on the continent, on the basis that they're basically the same. The challenge is going to be the other way. So if you're a EU processor processing European citizens' data, and you are using a UK sub-processor, then there's going to be some challenges. And to be honest with you, I don't know what the answer is for that. I suspect you will need to make use of some, either there's going to be some guidance about how it works in those kind of scenarios, but it's going to be a contractual relationship of some kind. But certainly the answer to your question, Alison, about UK processor using an EU sub-processor is that I don't see that there's going to be any particular challenges. because the UK are happy for you to process your data in the EU on the basis that it's basically the same law. It's just the other way around, that the EU aren't being quite so friendly in that view. Which I think is also the question that Dawn's asked, which is consideration for UK citizens' data being sent to sub-processors whose data centres are in the EU, and it is exactly the same answer. UK to EU data flow is going to be fine because the UK government's happy to trust that EU is a safe place for processing UK citizen data. It's going to be the other way around, where there's going to be some challenges. Okay, so I hope that's answered those questions. Has anybody got anything else they wanted to ask? If not, then quite happy to end the session now. But if not, if you can just quickly type your question, that would be great. Okay, so Sue's saying, with regards to adequacy, is there any update on the ECJ and the UK High Court rulings against UK government? Sue, are you able to sort of clarify what you mean in that respect? I think the answer is no, because it's pretty much as I've set out through the presentation, is that at the moment we're waiting to see what happens in a no-deal Brexit scenario. There's going to be some of these challenges that are going to happen between what the UK courts say versus what the ECJ says. Oh, I see. Right. Okay. So Sue's just clarified that she's referring to the surveillance regime. I'm not sure what the latest on that is. I've not heard anything specific about any particular changes, and this is the bit I was highlighting about. This could be the fly in the ointment with regards to an adequacy decision. So I think that's a watch this space question. I'm afraid I don't have an update on that. Okay, and there's just one further question, which is sort of a follow-up to what we were saying before. Do you think if it's an EU sub-processor, they do not need anything additional to permit the transfer back into the UK, i.e. as they are sub-processor, it is the UK-EU transfer which is relevant? If you're in the UK and you're using a processor in Europe, then not much is going to change. It's going to be when you're an EU, you're in the EU and you want to use a UK processor where the challenges are going to arise, because on the continent, they're not going to be able to pass data to the UK unless it's lawful for them to do so, because it will be referred to as a restricted transfer, as we currently look upon countries like the US and India in that examples I was using before. So yeah, if it's UK citizens' data being processed on the continent, being passed back to the UK or otherwise, that's going to be fine. It's going to be when it's EU citizens' data, so non-UK citizens' data being processed in the UK, where there's going to be some challenges. Okay. Well, if there's no other further questions, then I'm happy to leave it there, and I hope that the session was useful. As I said, I've recorded it, so we'll get a copy of the recording out to you and a copy of the slides so that you can refer back if necessary. But obviously, if there's anything that we didn't cover or you wish you'd asked, then drop me an email and I'll see if I can help you. Okay, well, nothing else is coming through question-wise, so thank you very much for joining it, this session about Brexit and EU data flows. I hope we all become a little bit more clearer in maybe a month and a bit's time, but I suspect we probably won't. Yeah, enjoy the rest of your week. Thank you very much for joining, and I'll share the slides and the recording at some point in the next day or so. Thanks very much.